I don't see Dr. Feibel. Are you on?
This conference will now be recorded.
Oh, how are
Okay,
you?
we are live again. We are streaming again, thanks to Julie Williams. For the record, I'll note that all the board members and staff who were present before are still present as we resume this committee meeting. Thank you, Dr. Schottenstein.
Yeah, thank you, Benton and Julie. So just to pick up, where Dr. Safran left off, I agree. You know, we can always start small with the sexual misconduct complaints and potentially expand down the road if we feel like that would be productive. But I think that that's where the excuse me, where the emphasis is right now. Yes, Dr. Feibel. Oh, John. Yeah, there you go.
I have a couple of thoughts, if I might. First, I have the utmost respect for Dr. Rothamel and Dr. Safran and trust in them, and I agree that that the system is working well. I don't think that's the issue here. I think the issue is giving the public confidence in our system and making sure, which is the reason we have public members, consumer members on this board. And I think it helps to bring a level of transparency to the system by having a consumer member in the system, in the making of the sausage, so to speak, as opposed to at the tail end of it. So I think it's very important that we add a consumer. Personally, I think it's very important from a transparency perspective that we add a consumer member. And I realize it's a lot of work, and it would be tough for me to do that amount of work that Dr. Rothamel and Dr. Safran do, and we're very thankful that they're willing to do it. And so I don't know how we would get a consumer member to do the work, but I don't think that should hold us back. I think we need to do what's best for the public on this board, and I think what's best for the public is to have a consumer member in that role. And so I would advocate for every case that a consumer member would help with that role. The second thing I was going to say is I have the same worries that Dr. Schottenstein does about or Dr. Rothamel, I can't remember who brought it up, about the number of board members that are able to opine on a case afterwards. I think and I'm certainly not a lawyer, but I think we're a little antiquated in how we think about this, and we need to think about it differently. Just because a licensee has had something back in 2010, an incident back in 2010 that Dr. Bechtel reviewed, doesn't mean that Dr. Bechtel can't be objective in 2021 about the case that he has seen at that point. So he shouldn't have to recuse himself from that case. If we can't be objective as board members, we're no different than judges. Judges have to be objective all the time and put things in their memory, take things out of their memory. You should be able to be objective. And so you shouldn't have to recuse yourself from every case that now comes up about that licensee. So I would advocate looking into that very fully on this committee to make sure that we're following the law, but interpreting the law as liberally as possible and still being legal.
Thank you, Dr. Feibel. Dr. Bechtel.
Yes, I'd like to, first of all, state that I do agree with Dr. Feibel's comments. Having been both a supervising member and secretary, the work intensity is incredible. You have no life. I mean, the hours spent is significant. When I was a supervising member and secretary, we would get 145 complaints a week, and I gave up every Saturday night for 2 or 3 years. My wife and I would have dinner at 5 o'clock, and then I would work until 11. So the consumer members would need to know that the work intensity is significant. I think transparency is really important, and as you'll notice, like today, I'll be abstaining on a lot of cases that go back to 2013 and 2014. So if we do rotate consumer members, and if the current process goes on, they're going to be touching more and more cases, and we may find that we may have to have 5, 6 abstentions voting on a particular violation. So that's one of the concerns I have is the impact that it will have on the number of people that would need to abstain on voting on a rule or an order. The other thing I think is I look back as supervising member and secretary. The one issue that always concerned me the most was sexual misconduct cases. And that's where I really felt that a public member involved in that process would give more credibility, more transparency to the public. So I think you get in a situation as a supervising member or secretary where it's a he said, she said situation. There's no witnesses. And it's important as a physician not to have any implicit bias that, you know, a doctor could never do that. We try so hard to be as objective as possible, but the addition of a consumer member gives a lot of credibility to that final decision in sexual misconduct. So I think if all the areas, that's where a consumer member, community member would be most impactful. Maybe that would be a good first step because there would be less time involved, less cases touched over time. But I agree with Dr. Feibel and with Dr. Schonstein that I think that the public really wants transparency. They want to make sure that we're not protecting our own. They want to make sure it's a fair process. And ultimately, getting a consumer member involved in all different decisions would be great. It's just, it's very, very time consuming. We could have difficulty with abstentions because of multiple cases being touched. Again, I'm abstaining from cases I saw in 2013 and 2014. It's not 2021, and it'll be a challenge. But I think these are changes that that the public wants.
Thank you so much, Dr. Bechtel. If I may, I'll just say that in response to one of Dr. Safran's comments a moment ago about how multiple public people touch the case along the way in the process, what I would say is it's the closing that's meaningful. In other words, that's when you should have a public member, ideally in closing a sexual misconduct case, especially, part of that process. And I also, just responding to the thought about a more liberal interpretation of, abstentions when somebody has looked at a case years ago, I'm certainly respectful of that and of the fact that judges a lot of times, have to maintain their objectivity when they see somebody back. I guess what I would say is that it just potentially makes things harder for us. It opens up another avenue of litigation for a licensee to make a concern about the case. So any other thoughts on this matter? Yeah, sorry, Mr. Jackalow.
I agree with everything that's said. The abstention thing, I think like you, I think there's always a question about, is that a litigatable issue? So there's the one thing, and I guess that's something that our lawyers would have to look into and see, is there a time period maybe that doesn't become an issue? 2 years maybe too soon, 5, 10 years, maybe that's not an issue, I don't know. Secondly, I think we're almost in the box on this one for sexual misconduct. I don't think we can get out of this box. I mean, it was the trigger point for this event. It's a recommendation from FSMB. I think we're kind of stuck with this one. And we can debate whether it expands beyond the sexual misconduct. And even then, I'm a little hesitant to expand it, because we're to expand. I mean, no offense, but what is a consumer member going to lend to a standard of care issue? Okay, that physicians and experts in the area already opined on. Substance abuse seems kind of the same thing. I think, you have people that are knowledgeable enough. I'm not sure that that's really going to be a trigger point either. So I'm just questioning, what more is there out there other than sexual misconduct? And again, here's the problem. I don't have the universe of that. Indictment on taxes. Again, I don't think you need a consumer member for that. I mean, I'm just thinking of the cases we've had. Sexual misconduct seems to be the one that fits the best, and obviously is the one I think we are really kind of committed to. So now it just becomes, if we expand it, I wouldn't want to expand it to everything. Let's get a list of where we think it makes sense, but I don't think it has to be a must-have or must-do. I think the sexual misconduct, though, is probably a must-do. And I think that Betty had brought up, splitting it between, perhaps her and myself might be the way to do it, because throwing it all on somebody's shoulder as a consumer member is a bit onerous. Even, again, I don't even know on the sexual misconduct. I think I heard, 145 a week. I heard 90. I don't know how much of that is misconduct, sexual misconduct. It may be a fraction of that. I don't know.
We hope so.
Dr. Feibel.
Can't hear you.
I think Betty had her hand up before I did. So do you want to speak,
Oh,
Betty?
yeah, of course. Sorry, Betty, I didn't see you. Please.
Dr. Schottenstein, thank you, Dr. Feibel. I think you've made your case, and I would withdraw my comments. I think you've made your case that we start with the sexual conduct, because, quite frankly, I think Dr. Rothermel and Dr. Safran have done a wonderful job, and so I think you've made your case, and I agree with Jacqueline that let's just confine it at this point to this sexual misconduct. I also want to underscore, I do think that we are being enormously conservative with regard to recusal. Yes, we may get some challenges statutorily. Let's deal with our in the courts. Let's deal with that when we do. But the fact of the matter is, I think that we can come up with a process that says when a case, say when the doctor or our licensee is off probation, or when we determine a case is closed, and obviously off of probation is an obvious place where case is closed, they've taken their courses, they've paid their fine, they've done all this thing, and there's not any other aftercare involved. That case is closed, and I think that we are being enormously too careful about recusal. And that sounds odd for a lawyer to say, but I think we can build safeguards without worrying about looking over our shoulder. Well, somebody may reverse us, because I don't think we can build the guardrails so that that there's enough distance that this is a new case and we ought to be able to approach it as that. Otherwise, every problem child, every problem licensee who comes to us more than once will be recused from. And I think those are the licensees that you want all of us involved in. So I would defer to our mute members, if you will, and I would politely suggest that we re-examine legally our recusal policy.
Thank you so much, Ms. Montgomery, for your thoughtful comments. And I know, Dr. Feibel, you want to speak. I think after Dr. Feibel, in the interest of time, let's circle back to the QA committee, because we sort of moved along past that. And I think we should have a talk about that as well. So go ahead, Dr. Feibel, please.
I'll be brief. Just to piggyback on Ms. Montgomery's comments, I think it is crucial that we revisit that recusal thing. The statute, if we have to recuse ourselves from everything, the way the supervising member and the secretary could rotate, we could all be boxed out of the case at the time of a hearing. And I don't think that any court would say that we all should recuse ourselves in those situations. So I think it is defendable, and I think we should find a way to do it. The second thing I'll say is, and I know this is obviously a losing argument hearing what people are saying, I think the public expects transparency in everything we do. And whether it be a standard of care issue or other things, I would respectfully say that the public wants consumer members involved. And there are standard of care issues that I know about that potentially could be issues down the road. And I just think having that transparency in our system is important. And I think if something comes up like the Strauss thing did, that was the trigger for this, but that doesn't mean that something else might not come up in a different field. And I think we are on firmer ground having a consumer member in that committee. And I think it protects the board a lot more, that it doesn't look like we're protecting our own, whether it be a standard of care issue or a sexual misconduct or some other issue. So I would respectfully disagree with the rest of what it sounds like the rest of the committee is saying, but I will go with the majority because that's how it works.
Right. Thank you so much, Dr. Feibel. So maybe we can circle back in the time we have to the QA committee. Does anybody have any thoughts? And I do. I can certainly start, but anybody have any thoughts about the Quality Assurance Committee and whether or not it is in fact in the best interest of the board and the public to reconstitute that? Ms. Montgomery.
I think it's important that we do it. We do an audit. We set up the process in which we determine how we do these audits, and use some of the cases that we see, as well as we do postmortems on in a rotating way. It reassures, again, not that our processes don't work, but it is again another reassurance to the public that we are sure we are belts and suspenders, and I think that's really important for not only the public, but to know that we're doing this, but also for us to check ourselves. We audit all the time. When I was auditor of state, we audit all the time. Didn't mean that we didn't trust anybody, but it means that you trust, but you verify.
Thank you so much. There may be two different things that we're talking about. When we talk about post-mortem, what that means to me is that perhaps during executive session, the board has the opportunity, after a case has been disposed of, to come together and discuss different aspects of the case. With a Quality Assurance Committee, what I think about is more that a committee reviews, these cases, in a randomly selected statistical way. So, for instance, let's say, X percent, let's say 5% of cases closed the previous month, right? Go to the Quality Assurance Committee for a review. So just using round numbers for a moment, let's say we average 500 closed cases a month, and let's say we audit 5% of those cases, right? So that's 25 cases. And let's say, round number wise, we have 5 members of the QA committee. So each committee member gets assigned 5 cases. And then maybe we could have those closed cases accompanied by some summary information, identifying the licensee and the complaint and the investigation information and the disposition of the case. And then the committee member could potentially, complete that form and indicate whether or not there's agreement or disagreement with how the case was handled. Then that could go back to staff, and staff could then assemble a summary, essentially, of all the cases reviewed by committee members that could be presented to the committee at the following meeting. And again, we could have conversations about whether or not there was discrepancy in what board members who reviewed the cases found versus how the case was handled. And then potentially the chair of the QA committee could give a full, report out to the full board, like we do with the other committees. That's sort of how I was envisioning it. Any other thoughts for the QA committee? Dr. Feibel.
I would agree with that wholeheartedly. I think there are 2 avenues. One is certainly a post-mortem of if the board finds out about illustrative cases that may have been tough or may have been problematic through review or something along those lines, being able to discuss those in executive session would be a great thing. I don't know legally whether we're able to do it or not. And then, like you say, the rest of the cases.
Yeah, the postmortem is a little trickier, I think, in terms of where we stand legally. Any other thoughts on the QA topic?
I think I don't disagree.
Sure, of course, Ms. Montgomery.
I don't disagree at all about a postmortem being separate. Then those are specific cases where we want to examine process and protocol failures and successes. I think that's great. How we fashion that legally, we can figure out. I'm not sure, and again, I think the staff can, working with you, Dr. Schottenstein, and others, can figure out a process. But I'm not sure. I'm not sure I would want our audit to, if we have 5 members and say we're choosing 25 cases, as onerous as that may sound, I would not want to only have one person looking at 5 cases. You may assign 2 members to look at 5 cases, so that we have the ability to have 2 points of view or several points of view. If you don't want to give them all the cases, you break them down to smaller numbers, but you make sure that you have more than one member looking at the same case for the quality review.
I appreciate that. And that, I also had that same thought, but I guess what I'm wondering is if, these cases are being assigned to individual board members, right? And this dovetails on the conversation we had before. And let's say that licensee comes back before the board, for another matter, right? Having had that licensee, having had that case reviewed by the licensee in an identified way where the board member has the identity of the licensee, does that board member then need to recuse in following matters? And so then if we have more than one board member review individual cases, then we've got more recusals potentially. So I was sort of kicking that around a little bit.
Yeah, and it doesn't matter. It may be that you don't have to identify them.
Well, so fair enough.
We can work that out legally, I think.
Yeah, I guess I was just wondering if that would be harder to, review the matter, in a de-identified way when ideally we would have the case and the investigation information in front of us. I guess it's possible, but it would be hard. But thank you for that. Any other thoughts on the matter?
I have a question, Dr.
Sure.
Schottenstein. So the Quality Assurance Committee reviews these. If they determine that they wouldn't have closed it or they would have done something else, what happens then? Is it shared and then the next time something similar comes up, they want a different outcome? Because almost every case has its own little nuances, and I don't understand what's going to come out of that to make us more transparent or make us make different decisions. I'm not opposed to anybody reviewing anything because that's important, but I just don't know how the outcome is going to affect us.
I guess I would say 2 ways. One is, my thought is, if a board member has a discrepancy, then I think the case goes back to investigations, with those comments. And I think investigations can sort of take another look at it in much the same way that if the Strauss matter had come to a QA committee member and that board member had said, wait a second, this is not okay, ideally that goes back to investigations. And the other way is, because we don't know what we don't know, maybe at some point we start to see a pattern, right, in terms of discrepancies and the nature of those discrepancies. Hi, Dr. Feibel.
Yeah. Along those lines, we keep saying in this meeting that nothing needs to change because nothing's wrong, and we're saying that based on the fact that no one's brought anything to our attention, but we've never checked and balanced ourselves. And this would be a way to be more confidently say nothing's wrong, because now we've had 2 other people look at these cases, and it just seems like, again, from a transparency perspective, we're doing a lot of Q&A, quality assurance QA, and if something comes up like the Strauss does, we have a lot more backbone to say, look, we were trying to prevent that from happening, and we are certainly trying to make sure we were doing checks and balances.
Thank you so much, Dr. Feibel. Mr. Giacolini. You're muted, Bob. Sorry.
All right, sorry. We had a quality assurance committee at one time. We got rid of it. Do we know historically why we had it and then we toasted it?
Stephanie, can you speak to that? Because I had that conversation with you as well at one point. It seems like we didn't really ever determine the answer to that question.
Yeah, no, so we don't know exactly why it was sunset. There's no reflection in the meetings as to why it was sunset. And I mean, I could guess that the committee felt like it ran its course and that they weren't seeing things in these audits. But we don't have any record as to the why.
Okay. All right. Thanks.
Thank you so much. Any other questions on this matter or thoughts?
I suspect that we're going to get an email from Dr. Steinberg who will tell us why. Because she was the one that raised the issue before we even had the FSMB, or when we got the FSMB report. And Dr. Steinberg is assiduous in following us on our board meetings. So hello, Dr. Steinberg, and you may have an answer for us.
Great. Thank you. Any other FSMB committee business today? Okay. Well, I thank everybody very kindly for participating today. Appreciate the discussion. May I have a motion to adjourn, please?
So moved.
Thank you.
Second.
Thank you so much. So all in favor, aye?
Aye.
Okay. See y'all soon. Thanks so much.